coming to you from the mountains and the plains. The only conservative voices brave enough to push back. This is the Conservative Daily Podcast with Joe Altman.
That's what the Second Amendment was designed to do. If you're going to do something to nullify or take away my rights under the Constitution, come get it.
Max McGuire.
When you look at politicians on the left, they need to convince people that they are victims.
A resistance to the resistance. And now your hosts, Joe Altman and Max McGuire.
And welcome back to another edition of the Conservative Daily Podcast. My name is Max McGuire. Welcome to the show. This is our episode number 221. Pretty cool milestone. Not a round number, but every time I pay attention to what number podcast episode it is, it always gets a little exciting as we see it tick higher and higher. A little bit of housekeeping before we get into the podcast today. We just got hit with another Facebook fact check. So Facebook is artificially going to block people from seeing our podcast. So it's more important than ever before, if you haven't already, to make sure that you text the word freedom to 89517. That's freedom to 89517, and you will get a text alert when we go live. Facebook can stop our show from reaching people's news feeds, but they cannot stop you from receiving our texts. So that's why we have that text system. Same goes for YouTube. We're going to probably start getting it from them. So again, text freedom to 89517. You'll get a text alert. And you know what? Let's see how bad it is today with the algorithm. Hit that share button. If you haven't already, hit that share button. Even if you don't normally hit the share button, hit it. Let's test the algorithm and see just how much Facebook is throttling us today. Another little bit of housekeeping. Our producer, Josh, has COVID-19. He has the China virus, the Wu-Tang virus. Wuhan, not Wu-Tang. Wuhan virus, the China plague, whatever you want to call it. He's got it. He did get a rapid test, so I guess there's a 50-50 shot. He might just have the common cold, but he is now quarantining. He's feeling good, in good spirits. He was just on the line helping our fill-in producer, Chaz, get everything settled. So everyone, give your best wishes to Josh. And since Joe was in the room with Josh yesterday, Joe is now going to the doctors. He seems well now, so just everyone keep them in your thoughts. Obviously, COVID-19 it's a serious virus if you have underlying conditions. According to the CDC and WHO, the vast majority of people who get it survive, but we do want to make sure that we're all praying and thinking of Josh and Joe as Joe gets checked out and Josh is recovering. So I'm solo today, so this might be a little bit more erratic. We were going to be going live with stuff about Eric Coomer. Joe was going to be bringing in a lot of stuff with Eric Coomer, but that obviously has to get pushed back to later in the week. So today we're going to be talking about the news of the day, which is this Texas lawsuit. The state of Texas versus the Commonwealth of Pennsylvania, state of Georgia, state of Michigan, and state of Wisconsin. Up until now, I'm just going to refer to it as Texas v. Pennsylvania. I guess the correct way to say it would be Texas v. Pennsylvania et al., which is the title if you're watching, but I'll just refer to it as Texas v. Pennsylvania. So, Mr. Producer, fill in Chaz. Everyone say good luck, Chaz, in the comment section. Go ahead and put up my screen. Flawless transition. Good job, Chaz. So this is the case that was filed last night, right before midnight with the Supreme Court. State of Texas, as I said, v. Commonwealth of Pennsylvania, Georgia, Michigan, and Wisconsin. It was filed by Ken Paxton, who's the Attorney General of Texas, and I'm very proud to be a Texas resident today. I'm glad that my tax dollars are going to good use. So people ask, why are they filing this late? Well, obviously, it would have been nicer if they'd filed earlier, as we've said in the past. Today is the deadline. It's not the final deadline, but today is the safe harbor deadline. Before we get to this, what does that mean? The safe harbor deadline is the last date in which states can certify their slate of electors to the Electoral College and guarantee that it will arrive in Congress in time for them to have a final certification vote. So as we saw in 2000 with Florida, it is possible for a state to send their Electoral College slates to Congress after this safe harbor date, but technically there is no guarantee that it will arrive in Congress in time for them to count it or that Congress will count it. So this is a big date. The final date, obviously, is December 14th, but today is one of those big, big dates. And it's important that, again, it will be possible for state legislatures and courts to reverse results after today. But it's this deadline just makes it harder to do that, like significantly harder to do that, significantly harder to claw back results that have already been certified. We're seeing some good news out of Arizona that the legislature apparently, without even going into session, is trying to actually contest the election. So the Constitution says that the legislatures have the right to decide the slates of electors for the Electoral College. Back in the day, it used to just be state legislatures, right? And as new states have been added to the Union, one example that we've talked about in the past was the election of 1876. That year was the first year that Colorado was a state voting in presidential elections. And Colorado was such a young new state, they hadn't yet created the whole statutory system for elections. So the Colorado legislature actually completely just decided how Colorado would vote in the Electoral College. Since then, and since that's how it used to be done, states now, basically all states, have the people vote. People vote, they vote for the electors. Believe it or not, when you cast your ballot, you're not actually voting for Donald Trump or Joe Biden. You're voting for the electors who are pledged to represent those candidates in the Electoral College. So the people vote, that then goes to the executive branch, Secretary of State, governor, they certify, and it goes off to Congress for final certification, and then the Electoral College for the vote. But the Constitution still says that state legislatures have the authority. So the ultimate question is, if state legislatures have ceded that authority to the executive branch, is that permanent? Can state legislatures reclaim their authority without having to pass a new statute or a new resolution that would require a governor's signature? Lots of people say yes, lots of people say no. But the point is that the state of Arizona, their legislature, is trying to challenge the certification outside of a special session. So as we mentioned, the governor is refusing, just like we saw in Georgia, the governor is refusing to call a special session, but the Constitution does not require that the legislature be in session. It just says that the legislature is the combination of its parts. It is all of the people in the legislature. So theoretically, they could all go to a Starbucks, if you're allowed in Starbucks anymore, I don't even know. They could all go to a Starbucks and have an up or down vote, and that would be the legislature's will. It doesn't require that they be actually in special session. It just says the legislature. They're still the legislature. Constitution leaves that deliberately vague. So semi-good news out of Arizona that the legislature is planning to contest it. But as I mentioned, everything I just mentioned is very, very debatable. And just as there are people who are just as there are people who say that that's a legitimate use of a legislative power, there are just as many people who say that that shouldn't be counted. And ultimately, it'll come down to courts who might be called to intervene, and it'll come down to Congress. Interestingly enough, it'll be Mike Pence who opens the envelopes and decides which slates of electors should be put to a vote. If, let's say, Arizona, the electoral branch, the executive branch certifies Joe Biden as the winner, but the legislature certifies Donald Trump as the winner, what would happen would be Mike Pence would receive an envelope with two different slates, one for Biden, one for Trump, and Mike Pence, as president of the Senate, would get to decide which one should be put to a vote. Then Congress gets to vote. No guarantee that Congress would vote that way. Theoretically, Republicans would have a majority of the delegations in the House and a majority of the seats in the Senate, so Trump should win, but you have turncoats like Romney and those people who are complete wild cards. They probably would vote against Trump out of spite. The point is, this isn't necessarily over. But after this safe harbor deadline, it does become a lot harder. And again, there's no guarantee that Congress would actually agree or even hear the challenges. But Texas is trying to come in at the last possible minute and file a lawsuit against, as I said, Pennsylvania, Georgia, Michigan, Wisconsin, challenging the legality and the constitutionality of how they conducted their election. So this podcast, we're going to be going through this, reading it, explaining how they're going about it, and then talking about whether this has any chance of actually succeeding. So why is Texas doing this? Let's settle this. If you look in the Constitution states that the Supreme Court is the ultimate venue for deciding disputes between the states. If you look at the majority of our history, the early parts of our history, when the Supreme Court heard challenges between states, it tended to be about boundaries, borders, right? Especially as new states got added to the Union, as those lines on the map got drawn. It's a young country. It's a young frontier. There are lots of disputes over where those boundaries, those border lines actually were. So for the longest time, Supreme Court actually heard a lot of cases about that. But lately, there have been more and more as states realize that on things like, look at the Affordable Care Act, right? that challenge to the Affordable Care Act that the Supreme Court just heard was actually lobbied by the state of Texas and other attorneys general around the country. If you look at the challenge to the not the DACA amnesty program, but Obama's second one called DAPA, Deferred Action for Parent Arrivals, whatever, basically trying to take all the DACA, the dreamers, and give amnesty to their parents too. The challenge against that, which ruled that that was unconstitutional, that was brought by the state of Texas. So you're seeing, and then the same is true against Trump, right? A lot of the challenges to Trump administration powers were launched by attorneys general in states like California, Oregon, Washington State, right? New York. Look at all the cases that New York has brought, challenging things like immigration policy. So states have the ability to not only sue the federal government, but also to sue other states. And the Constitution states that the Supreme Court is the ultimate venue for hearing those challenges. And that makes sense, right? If a state is suing another state, you wouldn't want that case to be heard in a district court within one of the states. You want it held and heard on kind of neutral ground. So ultimately, it's the Supreme Court. The Supreme Court can refuse to hear the case. That's their prerogative, absolutely. But this lawsuit from Texas, because it's a state versus a state, it is a fast track to the Supreme Court. You don't have to deal with the Obama judges on the district court level or the appellate level. You can just go right to the Supreme Court. So what is Texas actually alleging? And we're going to scroll down and read through this. Basically, if you read this, Texas basically provides three different problems that they have. And they're here under the bill of complaint. If you look at the bullet points, the first one, they say that non-legislative actors purported amendments to the state's duly enacted election laws in violation of the Electors Clause vesting state legislatures with plenary authority regarding the appointment of presidential electors. That's what I just mentioned. The Electors Clause of the Constitution says that the legislature has the authority to both choose electors and decide how they are chosen. So, based on that very clear definition, any change to how electors are chosen that goes around the legislature would be unconstitutional. Not unconstitutional at the state level. We're talking about violating the federal constitution. So that's bullet point one. That's the first main point of the Texas lawsuit. You keep going. It says intrastate differences in the treatment of voters with more favorable allotted to voters, whether lawful or unlawful, in areas administered by local government under Democrat control and with populations with higher ratios of Democrat voters than other areas of defendant states. So that is basically making an equal protections claim. You look at the 14th Amendment, that's the idea that everyone has the right to liberty, right? You can't violate that right on the basis of one of the protections that you're afforded under the Constitution. So if a state treats Republicans differently as Democrats, that violates the 14th Amendment. That violates the Equal Protection Clause of the 14th Amendment. So what this second bullet point is alleging is in places like Pennsylvania, where you saw much less strict enforcement of signature verification, for example, in Pennsylvania and Philadelphia. Philadelphia and Pittsburgh, than you would see in rural Republican counties. That's a big red flag. When you see that the law is being enforced one way in Republican areas and another way in Democrat areas, that's a big cause for concern because, again, it goes against the Equal Protection Clause of the 14th Amendment. And then the third bullet point is the appearance of voting irregularities in the defendant states that would be consistent with the unconstitutional relaxation of ballot integrity protections in those states' election laws. So it's not just, this is the important part, it's not, this lawsuit isn't about fraud. Well, it's fraud in the sense that these votes ultimately should be ruled illegal or unconstitutional. This is not a case that's basically going after Dominion, going after the people in Georgia who are alleged of filtering in, putting in unlawful ballots. This third part, it is a claim that not only did it violate the Equal Protection Clause of the 14th Amendment, but this is claiming that there are damages, and that's important. Saying that the irregularities prove that this had an impact. It'd be one thing to say, yeah, they changed their election laws, but can you prove it actually changed anything? Can you prove that the election results were different than they would have been if the laws weren't changed? That's an important part. To prove you have standing, you have to prove that there's harm done, right? If they were to change the laws and you can't prove that it actually hurt anyone or changed anything, then it really doesn't matter. There's no harm. It's kind of like if a tree falls in the forest and no one's there to hear it, does it make a sound? You can't just assume it. You have to actually prove it, right? So this third part is bringing in the statistical anomalies and irregularities that we've been covering on the show so much, and saying that these aren't just irregularities, these aren't anomalies. You can explain this. It's understandable. This is the result that you get when you change the election laws unconstitutionally and favor one political party over another when it comes to how ballots are processed, how signatures are verified, and the like. So we're going to keep getting into this. We're going to go state by state and read the specific claims that Texas is making. But before I do, I have to remind everyone, please do hit that share button on Facebook. Please do like the video. Please do comment on YouTube. Please do give us a thumbs up. Very important. If you haven't already, very, very important, you hit that subscribe button and the bell for notifications. We go live Monday through Monday through Saturday now, 2 p.m. Eastern. So make sure you hit that subscription button to receive notifications through YouTube as well. So it's interesting that they're not just claiming that they violate state law, though, and we'll see in a second, though, as we get into Pennsylvania. Texas is claiming that Pennsylvania's new scheme for mail-in voting violated Texas law and the Texas Constitution, and they're absolutely right. Right? The Texas Supreme Court heard this challenge, and they didn't disagree with the claim that the election was unconstitutional. Texas's constitution, Texas's state constitution, as we'll see in a second, says that you can only have an absentee ballot if you meet certain criteria. That's in the Pennsylvania state constitution. So when the Pennsylvania legislature allowed for no reason, no strings attached mail-in voting, that's a violation of the Constitution. The Texas State Supreme Court didn't disagree with that. They just said that the lawsuit was filed too late. I mean, that's the kind of BS that we see in states like New Jersey when you challenge something like New Jersey's concealed carry law, the fact that you need a justifiable need to carry a handgun in New Jersey. When you challenge that, what the Supreme Courts always come back with is that it is presumptively constitutional. Why? Because it's been on the books that long. So the concept of latches in this respect doesn't make sense. Something's constitutional or it's not. You can't say that an unconstitutional action can stand because it took you a month after the election to finally reach the Supreme Court. Doesn't work that way. So I'm very against the notion that latches should apply here. But it's interesting, as we'll see here at the bottom, it says all these flaws, even the violations of state election laws, violate one or more of the federal requirements for elections and thus arise under federal law. This is important. They're not just alleging that these are infractions of state law, which would belong in state court systems. They are saying that by violating their state law and how they perform these elections, ultimately violate the federal Constitution as well and federal law. It's important because that's and see they cite Bush v. Gore there. It's important in order to convince the Supreme Court that this is the proper venue to hear these cases. And they say, taken together, these flaws affect an outcome determinative number of popular votes in a group of states that cast outcome determinative numbers of electoral votes. That's an important line here. For when you look at the cases that are being tossed out by Obama judges, by liberal judges, what you're seeing is that they're saying that there's no evidence of fraud, and even if there was, there's not enough evidence of fraud to change the results. That's the line that these judges keep using. What Texas has put in this brief is very smart, because they're not necessarily saying that if you get rid of all of these votes, Trump will automatically win. They're just saying that taken together, these flaws affect an outcome determinative number of popular votes in a group of states that cast outcome determinative numbers of electoral votes. That is saying that these changes, if allowed to stand, will affect the ultimate result. There is a harm here. It's not just theoretical. There is an absolute harm, and they plan to talk about it. So that's here. You see that Ken Paxton signed it, as well as the rest of the people in his office. So I want to get into the specifics of this because no media channel is going to actually read through this. I was trying to get some background knowledge just going into this morning. Once I found that we didn't have Josh and Joe was out, and this was a fend for myself kind of podcast, I tried to watch some media reports, and they're all just giving 30 seconds to it. given 30 seconds to. Texas has filed a Supreme Court lawsuit. Experts say it's unlikely to succeed. That's how the media is reporting it. So we want to do a full deep dive today into all of these specifics. So let's go ahead and we'll go right down to the facts. Let me go down to 14. Be faster than scrolling. So we get to, where are these? We get to the facts. Oh, that was wrong. For whatever reason, if you type 14 into this, it doesn't actually take you where you want to go. So if we get down to the facts, here we go. Commonwealth of Pennsylvania. So they start, the Texas starts by saying, yeah, Pennsylvania has 20 electoral votes. They say how many votes, and then they mention that the margin is 81,597 votes. Then you look at paragraph 42. It says the number of votes affected by the various constitutional violations exceeds the margin of votes separating the candidates. That's an important point again. Basically trying to toss out the notion that even if there is fraud, it wouldn't affect the outcome because there's not enough fraud, right? And here's the big one. One of the big ones. Pennsylvania's Secretary of State, Kathy Brookvar, without legislative approval, important note, unilaterally abrogated several Pennsylvania statutes requiring signature verification for absentee or mail-in ballots. Pennsylvania's legislature has not ratified these changes, and the legislation did not include a severability clause. What is a severability clause? Severability clause is something that legislatures will add to a bill that says, usually it's just one sentence or two sentences long, and it basically says if anything in this bill is ruled unconstitutional, that does not automatically make the rest unconstitutional. Basically, it says that if you take out one bit, you can sever it up without destroying the whole thing. Basically, the house of cards doesn't necessarily need to come crumbling down if one little part of it is ruled unconstitutional. Most of the time, legislatures would do this if they want to protect a law, and that's one of the challenges going to the Supreme Court now over the Affordable Care Act, whether eliminating the individual mandate should topple the entire law, or whether that is severable, meaning that without the individual mandate, should the law be allowed to survive. It then goes on to say on August 7th, 2020, the League of Women Voters of Pennsylvania and others filed a complaint against Secretary Brookvar and other local election officials seeking a declaratory judgment that Pennsylvania's existing signature verification procedures for mail-in voting were unlawful for a number of reasons. So we saw this around the country, and a lot of the lawyers, that were doing this were actually the same lawyers connected to the Russia collusion dossier hoax, right? What's the law firm called? Perkins Coie. I always forget how to pronounce it. Perkins Coie. They're the same law firm that peddled the dossier. Well, they also have been going around the country and trying to challenge the way states have for the longest time verified absentee ballots. We saw this in Georgia with Stacey Abrams, what she did, suing the state government. We saw this in Pennsylvania. We saw similar lawsuits in Michigan and Wisconsin. This is the Democrats' game. They tried to push through universal mail-in voting through Congress, didn't work, so then they went to the courts to get the courts to overturn the long-standing ways that states have verified signatures. Meaning, don't be as strict. It's a pandemic. Don't be as strict. Let dubious signatures through. It's more important that we count all the votes than ensure that fraudulent votes are not counted. That was the argument that they made. It's a pandemic. They got judges to agree, and they got cowards like Raffensperger in Georgia to basically agree to all their terms. So they changed the law. Not to change the law. They changed the way the law is. You can't do that. If you're not a state legislature, you cannot change law. You cannot have a Secretary of State enter into an agreement with a third party to mediate a court fight and change the law that way. It's not how it works. You can do that for regulations and such, but you cannot change the law. So then they get into the Pennsylvania Election Code does not authorize the county boards of elections to set aside returned absentee or mail-in ballots based solely on signature analysis by the county board of elections. So this is important. One of the things that Pennsylvania did, and I'm not going to read it, you can read this as I'm talking. One of the things that Pennsylvania did was that the Democrats running Pennsylvania, they allowed for counties not to necessarily pre-canvass, because they're not allowed to start canvassing until election day, the morning of, but they allowed counties to, when they get an envelope, right, if they notice there's no signature or they notice there's something missing, they allowed them to call the person to allow them to cure the ballot. What's a cure? When you cure a ballot, you're fixing a mistake. So if you didn't sign it, right? If you wrote your name in just in print but didn't sign, curing a ballot in states that allow it would allow the election officials to call you up, say, hey, you forgot to sign it. Come on in and sign it. And you have X number of days to do that. In Pennsylvania, they allowed curing to happen at the county level when they weren't legally allowed to do it. Pennsylvania law says that, as you see right here, all mail-in or absentee ballots shall be signed by the applicant. It then says, I'm not even going to try and find the part. It's then the problem is that you're not allowed to cure ballots, so you're not allowed to even review the ballot, to canvass until Election Day. So it's not legally possible for any election official to see a ballot and have it cured before Election Day because they're not allowed to look at it, right? You cannot call a voter to cure his ballot and then claim that you didn't pre-canvass the ballot. You can't do it, right? Canvassing is going through and looking at whether or not all the requirements are met. So by having these ballots cured and by offering voters a chance to fix their mistakes, that proves that an illegal canvass was performed. Because again, you cannot call someone and tell them to come fix your mistakes and then claim that you didn't review the ballot to see if there were any mistakes. It just doesn't work like that. So we're seeing this. Yeah, again, these are all the different parts of Pennsylvania statute that basically says you have to keep the ballots safely sealed and locked until they're allowed to be canvassed. They're not allowed to be canvassed until 7 a.m. on Election Day. So that's just basically going into those details. And then they're talking about the fact that obviously they removed the ballots from these sealed and locked containers to check to see whether or not they could be cured illegally. That's a violation of law. So every ballot that did this is not a legal ballot because it was pre-canvassed. It was mishandled. And that's something that gets really sad. I have debates with people and they're like, well, what should the remedy be? Do you throw out the vote? Do you toss away someone's otherwise legal vote or potentially legal vote because it was mishandled by someone? And unfortunately, the answer is yes. We see this a lot with cases where you cannot prove the chain of custody. The chain of custody is important. If someone were just to take a bag of ballots home with them and then bring it back, you can't trust that they haven't put more ballots into it. I'm sorry. It's unfortunate, but those ballots are spoiled, right? And so, yes, everyone has the right to vote. And when you vote, your vote is finished when you put it in the drop box or you pull the lever or however your state does it. You do not have a right to just have your vote counted no matter what. There's plenty of ways that your vote can be thrown out, right? So it's unfortunate. And I that's why I vote in person, because I would never leave it up to chance whether my vote is counted or not based on whether or not an election official follows the law. No, I'm not interested in that. So that's why I always vote in person. I always recommend that anyone who is interested in voting, vote in person too. Who would possibly trust the postal service with their vote? Like, really? A bunch of like local and county bureaucrats? No, I wouldn't trust them with anything. Like anything. But and that's why, because if they mishandle your ballot, most states by law, that means the ballot's supposed to be thrown out. But what we saw this time around, not only were they relaxing how the signatures were verified, but we also saw that they're essentially making it harder to challenge whether or not the ballot should be thrown out. We know from example in Minnesota, in Milwaukee. In Milwaukee, the head of elections misplaced the thumb drive containing the entire count of absentee ballots for Milwaukee. It was misplaced for 10 to 20 minutes. That should have been completely tossed out. They claimed it was still in their chain of custody, but at that moment, no one knew where it was. You cannot say that something is inside the chain of custody if no one knows where it is. It's lost. It's outside the chain of custody. So we see this around the country. We saw in counties around Philadelphia that things just didn't add up with their chain of custody records. We're seeing other areas in Georgia now saying that they've lost their chain of custody records. Right? In Michigan, we talk about all of the problems with Wayne County and Detroit, how it just doesn't match up, right? That's a serious chain of custody violation. But we're saying, oh no, just count it anyway. Count it anyway. What does it matter? Count it anyway. And then Texas gets into, in addition, a great number of ballots were received after the statutory deadline and yet were counted by virtue of the fact that Pennsylvania did not segregate all ballots received after 8 p.m. on November 3rd. That is important. That is important. We know the Supreme Court not once but twice ordered Pennsylvania to make sure all late arriving ballots were segregated. The reason the Supreme Court had to order them twice is because they didn't listen the first time. We know that late arriving ballots were mixed in. We know it. We absolutely know it. We know that illegal ballots arriving after Election Day, people being allowed to vote after the election is over, were mixed in. We don't know how many, right? We don't know how many. Bookvar's claim that only about 10,000 ballots were received after this deadline has no way of being proven, since Pennsylvania broke its promise to the court to segregate ballots and commingled perhaps tens or even hundreds of thousands of illegal late ballots. That's important. What Texas is doing is they were referring to that previous court order and reminding the justices that the only reason Pennsylvania is even included in this part of it is because they didn't listen the last time the Supreme Court ordered them to do something. So then they talk about how the legislature is challenging it, wants to challenge it. Talking about the Ryan report, which found that ballots with no mail date was 9,000. Ballots returned on or before the mail date was over 58,000, and ballots returned one day after the mail date was 51,000. It's impossible for a ballot to be returned before it is mailed. That's part of the chain of custody argument, right? You say, okay, we mailed this ballot to you on this date. If then the spreadsheet says it was returned the day prior, there's something seriously funny about that. There's also something seriously funny to say it was mailed out on let's say, the first of the month, and it was returned the second of the month. Are we at a time when we're being told the post office is like really bad? Are we really supposed to believe that that the very next day after being mailed, people received it, filled it out, and resubmitted it? I don't buy it. I don't buy it at all. So then Texas gets into these nonsensical numbers alone total 118,426 ballots and exceed Mr. Biden's margin of 81,660 votes over President Trump. But these discrepancies pale in comparison to discrepancies in Pennsylvania's reported data concerning the number of mail-in ballots distributed to the populace, now with no longer subject to legislated mandated signature requirements, verification requirements. So basically it's saying it pales in comparison to the total number of ballots that were allowed to pass without the signature scrutiny that was required. So basically, Texas is challenging that the whole premise that Pennsylvania should be allowed to conduct an election in violation of their own state law. And Texas is saying, as another state of the union, they are harmed by fraudulent electors that don't deserve to be seated on the Electoral College being seated anyway. So then we look at Georgia. Anyone who wants to read this, we're not going to have time to read all 92 pages of it. So feel free to go and read this. It's really interesting stuff. Again, I'll remind everyone, if you're watching on Facebook, hit that share button. Give us a thumbs up, comment on YouTube. Make sure you give us a thumbs up, subscribe, hit the bell for notifications. We're being throttled on Facebook. So we really want to see if we can get a bunch of shares and see if we can break Facebook's throttling algorithm. So then we look at Georgia. Georgia's interesting because Georgia, we're seeing the same deal. We're seeing an agreement made between Georgia and Stacey Abrams and her groups, basically saying that COVID-19 is too serious. We can't be as strict with ballots as we normally are. So this whole challenge basically lays out that the legislature has basically created a statute that requires signatures to be verified, and that the state government, the Secretary of State, adopted a rule allowing the ballots to be processed before Election Day and for signatures to be allowed even though they might not be. Georgia law provides absentee voters the chance to cure a failure to sign the oath, an invalid signature, or missing information on a ballot's outer envelope by the deadline for verifying provisional ballots. In other words, 3 days after the election. To facilitate cures, Georgia law requires the relevant election official to notify the voter in writing. It says the Board of Registrars or absentee ballot clerk shall promptly notify the elector of such rejection, a copy of which notification shall be retained in the files of the Board of Registrars or absentee ballot clerk for at least 2 years. The problem is that in this case, Democrat Party of Georgia v. Raffensperger, they agreed to basically tell people that they made mistakes by phone. So the statute requires it to be conducted in writing, and instead they did it by phone. The problem with that is that you do not have a record necessarily of the phone call. When you just have people using their private cell phones, calling people up and say, hey, your ballot's wrong, come on in and fix it. You don't have a record of that communique put into state records for the statute mandated 2 years. So it might seem like a insignificant thing, but when you want to audit an election, right, which we want to do in Georgia, you need to have everything that you expect, right? If all of a sudden you say, oh no, we actually don't have any records of we don't have any records of contacting voters to cure their ballots because we didn't do it in writing. People just use their private cell phones. So unfortunately, we have no record. You can't challenge it because you can't prove we did it wrong because we didn't actually keep a record of it as we required. I mean, that's the logic that they're trying to use. It's interesting. I mean, it seems like something insignificant enough, but when you look at the right to challenge, the reason that these statutes exist is to ensure not only transparency, but that if there's funny business, it can be easily found out. And presumably, anyone who goes against the requirements and does it in a shady way that cannot be completely recorded and audited, you could presume that they're doing that to avoid scrutiny, to avoid people noticing what they are doing. This is an interesting thing, another part of it. Among other things, before a ballot could be rejected, the settlement that the state of Georgia went into with the Democrat Stacey Abrams required a registrar who found a defective signature to now seek a review by 2 other registrars. And only if a majority of the 3 agreed that the signature was defective could the ballot be rejected. But not before all 3 of the registrars' names were written on the ballot with a reason for the rejection. This cumbersome procedure, these cumbersome procedures are in direct conflict with the Georgia statutory requirements, as is the settlement's requirement that notice be provided by telephone. Exactly. So Georgia state law doesn't allow this. It says one person looks at it, verifies it. If it doesn't work, sorry, it goes into the batch, and then you send them a written notice to come and cure it. Right? That's the way the law says it's supposed to be handled. But they changed the law without going through the legislature to not allow one person to make the call, but to bring it to a committee. And unless you could convince one other person on the committee, it wouldn't get thrown out. Right? And even if it did get thrown out, instead of doing it by writing, they call them. Presumably because, we can't trust the post office. Can't trust the post office. This fraud, what they planned was in the works for years, how they planned to do this. And if you look at what happened in Georgia with Stacey Abrams, I think, and I don't have any reason to think this, other than it's just my gut, I think that the reason she was hooting and hollering and so pissed off about the election results was that she expected the steal to work. I think that Stacey Abrams thought that they had enough fraudulent votes to win. I thought they thought it. So when they said she lost by a very small margin, I'm sure she was pissed because she expected to win. She expected to steal it. Right? The only reason that you get really pissed like that, Stacey Abrams still has not conceded. That's how pissed she was. All these years later, she still hasn't conceded. Democrats still refer to her as the elected, the true governor of Georgia. You only get that mad when you think it's a sure thing, right? Anyone who goes into election should know, possible to win, possible to lose. The only reason you'd be that mad if you truly convinced yourself it was impossible to lose. So that's just my gut feeling on Stacey Abrams. But I think they tried this in Georgia a couple years ago, and they didn't quite get enough of the fraudulent votes to make it work. So if you look at the Texas lawsuit again, they're basically challenging that all of these changes to Georgia's law was not done in concert with the legislature, as the United States Constitution requires. Constitution gives the legislature the power to decide how electors to the Electoral College are chosen. The legislatures do not delegate that power to the executive branch. The legislatures wrote the statute on how the election should be run, right? Only the legislature can change it. Only the legislature can change signature verification statutes. Only the legislature can change the process for curing ballots. But what we saw here is Democrat lawsuits basically convincing the executive branch in Georgia to conduct changes outside of what the legislature prescribed. So honestly, it's an interesting argument. It's a very interesting argument. Things that seem very small and insignificant, but being very important in the end, and ultimately having the potential to change a lot of results. Quickly, we'll go through Michigan. Again, they're saying that the number of votes exceeded the margin. So they see in 2018, the Michigan Constitution provides all registered voters the right to request and vote by an absentee ballot. On May 19th, 2020, however, Secretary Benson announced that her office, and this is important, announced that her office would send unsolicited absentee voter ballot applications by mail to all 7.7 million registered Michigan voters. So this Constitution says you have the right to request. And in this year, the Democrat says, no, forget that. We're just going to send it to you automatically. So the question is, did they have the constitutional right to do it? Although her office repeatedly encouraged voters to vote absentee because of COVID-19, it did not ensure that Michigan's election systems and procedures were adequate to ensure the accuracy and legality of the historic flood of mail-in votes. In fact, it did the opposite and did away with protections designed to deter voter fraud. Interesting. So they talk about how the statute limits the procedures for requesting an absentee ballot, saying that an application for an absentee ballot under this section may be made in any of the following ways: by a written request by a signed voter, on an absent voter ballot application form provided for that purpose by the clerk of the city or township, or on a federal postcard application. The question is, did their system match that statute? No, it did not, right? So the Michigan legislature declined to allow the Secretary of State. If you look at it, it says the voter can request it, the clerk of the city or township can give it to them, or if there's a federal postcard application. Nowhere in that statute, MCL section 168.759, section 3, nowhere in it does it say that the Secretary of State has the authority to send these out. So those were illegal voter applications. It's a violation of state law. Again, it's something that seems small, but given how many of these things went out and how many people voted, that was the Democrats' plan all along, to remove the barriers to entry. No one was actually excited about Joe Biden. The people who were excited about Joe Biden were really mad at Trump, right? Joe Biden was the anti-Trump. No one went to the polls to say, wow, Joe Biden's my guy, right? I still have yet to see a Biden sign in my area of Texas. I'm sure they exist. I still haven't seen one. They're all taken down. My Trump sign's still up. Not taking that down. So it wasn't a pro-Biden vote. It was an anti-Trump vote. So in order to get people to the polls who weren't just rabid anti-Trumpers, they had to remove the barriers to entry, right? Oh, COVID-19 is too significant. It's too dangerous. Too dangerous. We have to just send everyone an absentee ballot, an absentee application. Right? It's too significant. We can't risk it. Well, no, the state law doesn't allow you to do that. Doesn't at all. So we hear Secretary Benson also violated Michigan law when she launched a program in June 2020 allowing absentee ballots to be requested online without signature verification as expressly required under Michigan law. MCL section 168.759, section 4. An applicant for an absent voter ballot shall sign the application subject to section 7612. A clerk or assistant clerk shall not deliver an absent voter ballot to an applicant who does not sign the application. You cannot sign online. I mean, it's possible, digital signatures, but it didn't meet the statute, right? And then further, section 168.762 and 7612, the qualified voter file must be used to determine the genuineness of a signature on an application for an absent voter ballot. And if the signatures do not agree sufficiently, or if the signature is missing, the ballot must be rejected. So you can't have an online signature. Online signature is where you just type your name. You can't compare that to anything. Like that, it's not comparable, right? It might be good enough to sign documents if you're renting an apartment or something, but when it says the signatures have to be verified and you have a written signature on file, you can't have just Times New Roman typed into a web browser form. So these were illegal absentee ballot registrations. They were illegally done. There was no possibility for a signature verification because it was all online. In 2016, only 587,618 Michigan voters requested absentee ballots. In stark contrast, in 2020, 3.2 million votes were cast by absentee ballot, about 57% of total votes, and more than 5 times the number of ballots even requested in 2016. So then they basically go on to say that these were unconstitutional because you can't just change the law like that. You can't just ignore the law like that. Michigan also requires that poll watchers and inspectors have access to vote counting canvassing, and this is where they go into that, where they kick them out. Local election officials in Wayne County made a conscious and express policy decision not to follow MCL section 168674-675 for opening, counting, and recording of absentee ballots. That's where they were kicking people out of Wayne County. Remember when they were dragging people out and everyone was cheering? Violation of state law. So it's interesting because we all knew this, but when you put it like this is the problem. They're going to say, well, you should have challenged this before. Here's the problem. If you challenge an election before the election is conducted, you can't prove damages. You cannot prove that the changes actually hurt anyone. But the left says if you wait until after the election, then it's too late. They say laches is in effect. Laches is the notion that you deliberately wait long to try and cause a harm. That's not true. It's been, 5-6 weeks since the election? The reason that these are reaching the Supreme Court now is not because the party's waited too long. It's just that's how long it takes to get to a Supreme Court. Build a case. So you can't sue over an election before it's held because you can't prove damages. And the left says if you sue afterwards, sorry, you waited too long. Basically saying that unconstitutional votes have to cast. And then here they get into the 71% of Detroit's absent voter counting boards are unbalanced. We've talked about that on the podcast before, not recountable. So quickly, before we end the podcast for the day, to get into Wisconsin. Same kind of issues. I mean, this is why they're all together in the same lawsuit. Wisconsin statutes guard against fraud in absentee ballots. It says, quote, voting by absentee ballot is a privilege exercised wholly outside the traditional safeguards of the polling place. The legislature finds that the privilege of voting by absentee ballot must be carefully regulated to prevent the potential for fraud and abuse. That's Wisconsin statute, section 6.84, subsection 1. So the legislature said that it's not the same as voting in person, right? There's extra scrutiny because it's much easier to commit fraud. And yet what we're seeing, in paragraph 106 here, is in direct contravention of Wisconsin law, leading up to the 2020 general election, the Wisconsin Election Commission and other local officials unconstitutionally modified Wisconsin election laws, each time taking steps that weakened or did away with established security procedures put in place by the Wisconsin legislature to ensure absentee ballot integrity. One of the things they say is drop boxes. Not allowed to do drop boxes. They did it anyway, right? They did anyway to facilitate the return. The problem with drop boxes is if they're unmanned, you can't tell how many ballots someone's putting in. If ballot harvesting is illegal and you have an unmanned drop box, how can you possibly know that the person dumping 20 ballots is related to them, right? If you drop them off at a clerk's office, at least the clerk can look at them and see that they're all different last names and say, you're not related to all these people. They're not your direct family members. But when you have an unmanned drop box, you can't perform that check. So you see here in Wisconsin's election code, alternate absentee ballot sites. And then they detail the procedure by which the governing body of a municipality may designate a site or sites for the delivery of absentee ballots, other than the office of the municipal clerk or board of elections commissioners, as the location from which electors of the municipality may request and vote absentee ballots, and to which voted absentee ballots shall be returned by electors for any election. And it says, the statute says, any alternate absentee ballot site, quote, shall be staffed by the municipal clerk or the executive director of the Board of Election Commissioners or employees of the clerk or of the Board of Election Commissioners. Very important. The statute says you can't have an unmanned drop box. It must be staffed. It says shall be staffed. That's not should be staffed. It's not may be staffed. It says shall be staffed. So any drop box that wasn't staffed was an illegal drop box. Again, I'm really sorry. But as the law is written, if you put your ballot in an illegal drop box, that is outside of the chain of custody requirements within the state, right? You can't count them. I'm sorry. I'm sorry that you were too lazy to go to your election office and you wanted to do the one right down the road. I'm sorry. I'm sorry you couldn't pay for the postage. I'm sorry. But as Wisconsin law says, voting by absentee is not a right, it is a privilege. You have no right to vote absentee in Wisconsin. It is a privilege subject to stricter enforcement of the statute. But what we saw here is that they completely ignored that. They completely ignored it. Unmanned absentee ballot drop-off sites are prohibited under Wisconsin law. Wow. Then you see the fact that they were mailing them out. There was actually one court ruling that allowed them to email ballots. Just think about that. There was one court ruling in Wisconsin that said if you haven't yet received your ballot by a certain date, you could notify your county or your town, whatever, and they would be allowed to email you a ballot. That is very illegal. Nowhere in the statute are they allowed to email ballots. It's just not there, right? On March 25th, this is an important one, 2020, in clear violation of Wisconsin law, Dane County Clerk Scott McDonald and Milwaukee County Clerk George Christensen, again naming names, both issued guidance indicating that all voters should mark themselves as indefinitely confined because of the COVID-19 pandemic. But if being afraid of a respiratory virus doesn't make you indefinitely confined. That's if you are really sick, on hospice, right? Injured, disabled, can't physically leave your home. Being afraid of a respiratory virus is not indefinitely confined, right? It's not indefinite. You can leave at any time. Indefinitely confined is supposed to be people who physically can't leave. But we see here, they're naming names. They're naming the Dane County and Milwaukee County clerks, the two Biden hotbeds. We're encouraging people to use COVID-19 as an excuse to label themselves as indefinitely confined. Why is that important? Because if you're indefinitely confined, you do not need to show ID. You can register and apply to vote absentee without showing ID. Again, as we saw in Wisconsin statute. Wisconsin statutes require that if you want an absentee ballot, because it's so much easier for fraud, you have to show ID. You have to show ID. Same reason they don't just let you apply online, right? You have to show ID. If you're indefinitely confined, there's a provision in the law that's basically a compassionate provision. So, okay, you're indefinitely confined, you're on hospice, right? You're cancer treatments, you can't leave the house, whatever. Compassionate, we're not going to force you to get an ID. If you can't leave your house, you probably can't get to the DMV to get a brand new license if it expired. So we won't require it, right? It's a compassionate use thing. But if everyone subverts the requirement for photo ID and says that they're indefinitely confined when they're actually not, what you have are a bunch of illegal ballots because they did not show ID. They used it to circumvent voter ID requirements. I mean, it's really, really a genius from a sick, twisted way how well thought out all this fraud was. Really, really. And again, yeah, it just says here, it was designed an attempt to circumvent Wisconsin's strict voter ID law. So then you get through all of it. They talk about the statistics about how it's just not possible for that many more people to be indefinitely confined. It's just not possible. It's not like there's a mass outbreak of polio and everyone can't move anymore. These were not indefinitely confined people. These were people gaming the system to get an absentee ballot without having to meet the requirements of the statute. So then they get through some of the things that Trump campaign officials and poll watchers saw. We've covered these on the show before. I don't need to get into these too much. Talking about box truck delivery driver subcontract with the U.S. Postal Service to deliver truckloads of mail-in ballots. That's really sketchy, right? So ultimately, we've talked about some of this. We talked about a lot of it. But why is this important? Because it violates, as right here, as I said, the Electors Clause. It violates the Electors Clause, which is specifically that the legislatures of the states get to decide how electors to the Electoral College are chosen. They can either choose the electors themselves, or they can create the election system in statute that determines it. All states have that now. There's not a state in the union that doesn't have an election statute. There are elections. But that's because the legislature has taken their constitutional authority under the United States federal Constitution and said, you know what? We're going to let the people choose. And this is how they're going to choose. The executive branch of these states does not have power to decide how elections are to be run. They administer the elections. They can have regulations to fill in the gaps where statute is empty, but they cannot change statute. The Constitution does not say legislatures have the right to decide how electors are chosen, and once they decide that, then the executive, governor, and the secretary of state can change it. That's not there, right? So these were unconstitutional changes. So that is what I think has been lacking in a lot of the lawsuits that we've seen, making a very strong constitutional argument that not only is this a violation of state law, not only is it a violation of federal law, but by violating the federal Constitution, fast tracks it to the United States Supreme Court. The ultimate question, and we can go ahead and take off my screen, Mr. Producer. The ultimate question is whether or not there's enough time to change this. As I said, this Supreme Court case was filed last night just before midnight. Today is the safe harbor deadline, meaning if any results are changed in states after today, there's no guarantee that Congress will receive those changes. No guarantee. That's scary, right? This is a legitimate lawsuit. The things here are true. They violated state law, all 4 of these states, and in doing so violated the federal Constitution because the violations were not allowed by the legislature. So will this work? That's the question. That's the question. They just filed it. I don't think it's been docketed. We know that the Pennsylvania suit, the deadline for Pennsylvania to submit their brief was today. Justice Alito is trying to fast track that, knowing that today is the safe harbor deadline. Is it possible? Yes, it's possible, but we've never been here before. I can't show you precedent for the Supreme Court overturning the results of 4 states after a safe harbor deadline, after the states have all certified. Right? There's no precedent. In 2000 in Florida, the whole deal was that the state hadn't certified yet. Supreme Court was intervening because the state hadn't certified. It hadn't all been sent up to Congress. There were challenges, legitimate challenges. We've never had a point. We've never had a point where the Electoral College has voted and the Supreme Court has overruled it. I don't think that's possible. Joe is a little bit more optimistic about that. I'm not, and that's not me being a Debbie Downer. I'm just saying there's no precedent for it. There's no precedent. There's nowhere you can find in the Constitution that the Supreme Court can overrule the Electoral College. It would be precedent setting. It would be brand new. Again, possible. I don't know if it's likely. So what we have between now and the 14th to get this thing done. 14th is the date that the Electoral College will vote. That's the deadline by which Congress has to certify. That's our time frame here, people. So this Texas lawsuit, exactly what we needed, but we needed this a couple weeks ago. Then again, it's so well written, it's so well researched, it's so well laid out that I don't think you could rush it. I don't think you could have done this work 2 weeks ago. As we saw, Sidney Powell, I love her. You go through her briefs, there are typos. There are mistakes, there are misspellings. Now that comes with the territory. When you rush something, trying to get something through as fast as possible, that happens, right? But to do it right, it takes time, which is why it's so ludicrous when you hear these judges say you waited too long, tough. Well, that's going to be it for this edition of the podcast. Hope you enjoyed it. We went through it. It's 92 pages, so we'll leave a link in the comment section for you to read the whole thing. We can't read the whole thing on air, obviously, but we tried to hit the main points so you could get a feel for what was going on and what this Texas lawsuit is about. If you like the podcast, we are being throttled by Facebook heavily. We hit 400, 500 people watching at the same time earlier this week. Now we're down to 187, all because we got fact checked. So make sure that you text the word freedom to 89517, freedom to 89517. You circumvent Facebook. We'll send you a text message when we go live. Click the link. Facebook then won't be able to stop you from watching. Do that. Also, there's a link in the description to sign up for our email newsletter. Very important. If we do get kicked off of Facebook, that and the text club is how we're going to get the word out for where we're going to go next. If you like the show, please help us move up in the rankings. We were at number 8 a week and a half ago. We've dipped down lower. I think we're in the 40s right now. It happens. You go up and down, but we really do need you to leave good reviews on Apple Podcasts. There's a link in the description. Not only that, we need you to subscribe and download. I know it's annoying, but if you can't watch the show, at least you'll have the audio version to listen to as you go about your day, and it really does help us. We're about to announce some really big partnerships that we're working on, really big partnerships to help us monetize, grow the podcast, and actually provide better production value, similar to what you see with Louder with Crowder and things like that. But the only way we get there is by proving the numbers. So Facebook helps, YouTube helps, but the best metric to do that is audio downloads, specifically Apple Podcasts. So please make sure you subscribe on Apple Podcasts if you have an iPhone, iPad, MacBook. If you don't, if you're an Android guy, you can find us at Google Play Store. We're also on Spotify, Pandora, iHeartRadio, TuneIn, and Podbean. We go live 2 p.m. Eastern, Monday through Saturday. So make sure you like and follow our Facebook page, subscribe, hit the bell for notifications on YouTube as well. We're also on Parler. Follow us at Conservative Daily. I'm at Max McGuire. Joe is at Joe Altman. So feel free to follow us there. And link in the description, we do have our Christmas t-shirt. Our Christmas t-shirt. Let me go ahead and put that on the screen real quick. Mr. Producer, go ahead and put up my screen. So we have the Come and Take It women's tee. You also have the classic tee, Come and Take It Christmas, modeled after the Texas battle flag. When the Mexican army wanted to take their cannons, they said, okay, you want them? Texas said, come and take them. Come and take it, modeled after the Spartans at the Battle of Thermopylae. If you like the channel, want to help support the channel, pick up one of these t-shirts. Still available in time for Christmas. If you do rush shipping, I'm pretty sure it gets you with standard shipping, but we're at that window now. So if you definitely want it before Christmas, rush shipping, we'll get it to you. They make great gifts, and they tell the world that you're not going to bow down to the demands of Anthony Fauci and everyone else who want to cancel Christmas. So you can go ahead and take off my screen. Everyone in the comment section, tell Chaz he did a good job. He's probably going to be our producer for a while as Josh recovers. So just let him know in the comment section how good of a job he did. Well, that's going to be it for this edition of the podcast. Again, my name is Max McGuire. Remember that the fight to take back our country clearly is not over yet, but the only way we win is if we all stand up and fight together.